When is an employer responsible for an employee's actions? Imagine you're walking down the street and suddenly get hurt by a delivery driver. You might wonder, who is responsible for this accident? Well, in personal injury law, there's a principle called vicarious liability that helps answer that question. This rule says that employers can sometimes be held responsible for what their employees do while working. But it's not just about any mistake. It has to happen in a specific way. An employer is responsible when the employee is acting within their job duties or something closely related to their work. For example, if a delivery driver causes a car accident while making deliveries, the employer could be liable. This is because the driver was doing what they were hired to do. The law looks at whether the employee was working at the time of the incident and whether their actions were connected to their job. The key is the relationship between the employer and the employee. The person causing harm must be an employee or someone working on behalf of the employer. The employer has control over their work and how it is done. If someone is an independent contractor, the employer usually isn't responsible for their actions. Another important point is whether the employee was acting within the scope of their employment. If they were performing their job or doing something related to their work, the employer might be responsible. But if the employee was doing something personal, like running a personal errand or intentionally harming someone, the employer probably isn't liable. This idea is often called respondeat superior, which means let the master answer in Latin. It emphasizes that employers are responsible for their employees' wrongful acts when those acts happen during work. This helps injured people get compensation from employers who are more likely to have the money or insurance to pay damages. However, if an employee acts outside their work duties or commits a wrongful act that is completely unrelated to their job, the employer is not responsible. For example, if an employee gets into a fight outside work hours and causes injury, the employer usually isn't liable. In short, an employer is responsible for an employee's actions when those actions happen during work and are connected to their job duties. This is the core idea behind vicarious liability in personal injury law. It helps ensure that injured parties can seek fair compensation from the party most likely to have the resources to pay.